Hello everyone and welcome to Auspol Explained. I, as always, am your long curly-haired host David, and today we will be talking about the dismissal of the Gough Whitlam government in 1975. November 11th, 1975, Gough Whitlam goes to Government House. His plan was to advise the Governor-General John Kerr for a half-Senate election because the Senate, controlled by the coalition, was blocking his supply bills. Money was going to run out at the end of November. This was going to be a bit of a problem, which we'll get into in a bit. Instead, John Kerr surprised Gough Whitlam by dismissing him, saying that he was no longer Prime Minister and instead commissioning Malcolm Fraser, the leader of the Liberal Party, as the Prime Minister. Malcolm Fraser then advised a double dissolution election where Whitlam, now the leader of the opposition, lost. This has been a controversial moment and discussed at length for the past 50 years. It spawned all sorts of partisan discussions about Labor, Liberal, the role of the Republic, some accusations that Kerr was a CIA agent, and all sorts of things that we will not be discussing in this episode, because today I'm just going to be focusing on the constitutional elements of the dismissal and the actions around it. And with me is, I suppose, friend of the show, Professor Anne Twomey. How are you doing?
A bit croaky, but I'll hopefully survive. I'm in Oxford and have collected what's known as fresher flu over here.
That's not a real background you've got behind you. You're not just sitting in one of the picturesque English parks. You've got a Zoom background because you've just moved. Why are you in Oxford, by the way? Why have you moved? Closer to some research archives?
It's just temporary. It's a sabbatical in Oxford for a couple of months at the beginning of the term. But I also have been down at Windsor Castle doing research in the Royal Archives and reading the correspondence between Governors-General and the Palace from days of old. So I'm quite up to speed on some of the early stuff that happened as well. But for the moment, we better probably concentrate on 1975.
For those unfamiliar with your work, you have a YouTube channel, Constitutional Clarion, which is linked in the description. You have done multiple videos in the lead up to November talking about the various aspects of the dismissal and the constitutional elements around it. So people definitely should go check out your YouTube channel, Constitutional Clarion. You're not just a random YouTuber, you are a professor of constitutional law, and you're an expert in this and have published multiple books. Let's start with the stakes of the dismissal. So as I mentioned in the intro, money was running out, right? The government has to pass a supply bill periodically to actually spend money on things like public servant wages, but it was running out at the end of November, and the coalition was refusing to pass the next supply bill in the Senate. So what would have happened if supply ran out?
First of all, it's not an absolute drop-dead date where supply runs out. It was running out progressively for different departments, so it depended on how they'd spent their money and budgeted. So for some places, it already had run out. For others, it would run out mid-November, and then the last day for being able to pay public servants was towards the end of November. But what was actually covered by these appropriation bills is public service wages. That also includes the Defence Force, so that meant people just would not receive their next paycheck. It also was payment for suppliers to the government, so anyone who had a contract with the government to supply wouldn't get paid as well. So they were the key things. There were other things, however, that are already covered under existing appropriations, so standing appropriations as they're known. So the government automatically pays out under legislation things as they come due, like pensions, for example. So those kind of things, pensioners would still get their payments. However, it depended on whether there were the public servants there to actually process it. So there was uncertainty about whether people would turn up to work and do their work if they weren't getting paid. And so there was a lot of uncertainty about what would happen. It hadn't happened in Australia for quite a long time. It had happened back in Victoria in the 1800s, so a couple of times around the 1860s, 1870s. And it was absolutely catastrophic when it happened in the past. So people weren't able to pay their mortgages. So their mortgages were called in and their properties were sold. That caused property prices to spiral downwards. There was an on-flow effect to businesses or whatever because people couldn't pay for They had no salary, they couldn't pay for things, and then businesses weren't getting business, and it just had this terrible spiraling effect. Money lenders came out of the woodwork and were charging people enormous amounts of interest, and there were quite a lot of suicides. So people died as a consequence of when this happened in the 1800s. So there were very good reasons not to let it happen this time. And the one thing to remember is that back in the 1800s, when that happened, on both cases where the governor didn't take action to sack the government and end the dispute over supply, the governor was either, in one case, recalled, so he was brought home in disgrace, he was sacked effectively, and in the other one, he was demoted and he was sent to Malta. And why? Because the British government said completely unacceptable to allow a government to be able to govern without supply. And so ever since then, every governor and every Governor-General has always insisted that supply be maintained. And if a government can't maintain supply, it has to either resign or secure an election. And also when governments ask the governor or the Governor-General for election, there's always a written requirement that they put in their letter saying, I have supply to cover the period. And that's been consistent through the whole of the 20th century, leading up to the 1975 dismissal. So none of this was unknown at the time.
That sounds like a bit of a crisis to me, which I can see would put some pressure on John Kerr as the Governor-General to consider his options to resolve this crisis, and his solution was to exercise the reserve powers to dismiss Gough Whitlam. Could you explain to us, what are the reserve powers?
So the Governor-General has a lot of powers that are given to him or her in the Constitution. They include things like dissolving Parliament and appointing the Prime Minister or removing a Prime Minister, and a whole lot of other things. Now, ordinarily, those powers are exercised upon the advice of the relevant responsible ministers, so the Prime Minister, for example. However, there are some powers where the Governor-General has a discretion and can exercise those powers without the advice of the Prime Minister or even contrary to the advice of the Prime Minister. Now, you might ask, why? Why do you have that? Well, just imagine to yourself that you had some kind of autocratic government that was trying to govern without, the support of Parliament. Say it had lost a vote of no confidence or refused to resign and it kept on wanting to govern. Okay, who then gets to control that? And that power ultimately is given to the Governor-General. So that if you had a government that lost the support of the House of Representatives, that then just prorogued Parliament and decided to govern without Parliament, govern without supply, maybe using the banks or something or other, who gets to stop them? The Governor-General. And that's why they have that power. And that's also why we are trying to appoint people to be Governor-General who are independent, but who have gravitas and wisdom to be able to exercise those powers. Now, in terms of a power to dismiss a government, extremely rarely used, but nonetheless important that it's there. But the point here is that the Governor-General does have discretion in some circumstances to act without the advice or contrary to the advice of the Prime Minister. But, and this is the key thing, that's not to be used just because they want to. It's not about the Governor-General's personal desires. It's about restoring constitutional government. So it has to be done for a purpose that is constitutional in nature. So it could be to refer matters back to the people in an election. It could be to restore the system of responsible government, but it has to be exercised for a constitutional purpose, not just for a personal purpose.
The story of the dismissal is basically centered a lot around money, but a precursor to the dismissal is also about money. Many discussions of the history of the dismissal involve mentioning of a thing that happened before called the Loans Affair. The Whitlam government wanted to borrow $4 billion US for some national resource projects. That was later demoted down to $2 billion, and the way that they went about getting the authority to do this, they ultimately did not do this, but the mechanism the Whitlam government went about doing it was to get approval via the Federal Executive Council, which advises the Governor-General. Now, the particular meeting, the first meeting where it was signed off, yes, you can borrow this $4 billion, you don't have to go through the Loans Council. John Kerr was not at that meeting. In December 1974, he was at the ballet watching Romeo and Juliet. He did, however, sign off on the minutes of that meeting the next day. Fraser claimed that this was improper. He claimed that Whitlam was trying to go around the Constitution, subvert Parliament, and try and get authority to get all this money without proper parliamentary approval. So what were the legal and constitutional issues around the loans affair? Was Fraser correct? And also, is it an issue if the Governor-General is not personally there to sign off on Federal Executive Council decisions?
Well, it certainly had a bad smell about it, I can tell you that much. So what we need to do here is go back a little bit in terms of the Constitution. So back in the early days, around about the 1920s, before the Great Depression, there was an amendment to the Constitution which allowed the Commonwealth and the states to enter into certain financial arrangements to manage things like borrowing money. And the idea here was that if you all were not competing against each other and dealt with things collectively, you'd get a better deal. So that was passed, and one of the requirements there was that if you wanted to borrow substantial amounts of money, you had to go through the Loans Council. And that meant you'd have to reveal what you were doing and the terms of what you were doing, and then it would be debated and agreed upon. Now, there was an exception for temporary measures. And Whitlam and friends did not want to go through the Loans Council because they were doing this in a dodgy way. They weren't going through the normal routes in the money market. They were getting shady characters in the Middle East to try and get access to petrodollars at a lower rate. Now, it's good to get money at a lower rate, but not necessarily good to go through people who have actually no standing and of dubious backgrounds. Treasury had been completely opposed to what they were doing, but nonetheless, they wanted to do it anyway. So they went to Executive Council saying, well, this is a temporary measure, even though it's for infrastructure projects which are supposed to run for 20 years. Okay, by anybody's measures, a 20-year loan in an amount that was absolutely enormous for the time for infrastructure that was an ongoing thing was not a temporary measure. And nonetheless, that's what they wanted to do. So the best way of avoiding a Governor-General sitting there and saying, hang on a minute, that's not a temporary measure, and eyeballing you in the meeting of the Federal Executive Council is to engineer it so that you hold it when the Governor-General's not there, so that afterwards it's already been approved. All the Governor-General has to do is sign it on the paperwork, and you hope he's not going to ask any questions. So that's what happened. They held the Executive Council meeting in the middle of the night. It was sometime, I think, after midnight in Canberra, when they knew the Governor-General was in Sydney. The next morning, Governor-General, very surprised, ordinarily would always have been told in advance that a meeting of the Executive Council was required, and therefore he would have made himself free to be able to attend. So he'd had no notice of it. He just got the documents, and then he sees that they're asserting this is for a temporary measure, and he knows as well as everybody else in the world that really it's not a temporary measure. So he does seek legal advice. He does ring the, I think it was the, I've forgotten now, it was either the Attorney General's Department or the Attorney General to get legal advice to the effect that this was a temporary measure. They did give oral legal advice that it was a temporary measure, or that it was at least, quote, arguable. Frankly, it wasn't even arguable. And he gritted his teeth and he signed the thing, not very happy about the entire business. So that was sort of part one in terms of using the Executive Council rather than going through the normal mechanism of the Loans Council, which was a constitutional requirement because of the amendment to the Constitution back in the 1920s. Second part of it, though, and the thing that actually caused the coalition to block the budget bills was not the loans affair in itself in terms of the way it was done. It was the slow drip scandal that came out about how the government had got this dodgy man from Pakistan to try and get this money for them. And then there was a second scandal about Jim Cairns getting a Melbourne businessman to try and get money for them. and then there was misleading Parliament, and then there was Cairns being sacked, and then there was Connor being forced to resign, and more information kept on coming out about how Parliament was misled, etc., etc. So this just snowballed into a huge controversy over time. So it wasn't just the beginnings of how the loans affair started, but it was all the dodginess along the way, and a general sense that the Whitlam government was completely amateurish and unable to deal properly in relation to money, particularly with overseas borrowing.
Fraser then takes this as a reason to be like, we should block supply, but at that point, the Whitlam government had revoked its authority to actually borrow that money. They didn't borrow that money, and as you just mentioned, Connor and Cairns had resigned from the ministry, and therefore, is it fair to say that technically, therefore, the loans affair was resolved?
There was more and more and more. So, for example, in relation to the Jim Cairns thing, they went through it in Parliament. He said, no, I haven't offered anyone a commission to do this. And then the opposition had in their hand a letter from where he'd offered a commission of 2.5% on one of these massive loans. And then Cairns says to Whitlam, and Whitlam tells Parliament that Cairns has retrieved all these authorities, these loan letters. He's retrieved them all and he's destroyed them. And then another one appears that Cairns wasn't telling the truth. He hadn't retrieved the letters and they were still out there. So even though it had been resolved to the extent that the formal authority to borrow had been revoked in the Executive Council, and the ministers, Rex Connor, he'd been told to revoke all authority to Khemlani. Khemlani was still out there trying to get money, and Rex Connor was sitting by his telex machine at night waiting for it, even after he'd told everyone and he no longer had the power to do it. And the same with Jim Cairns. Even after Jim Cairns said, no, there's no authority for anyone to do this anymore, they were still out there trying to get the money. So because we've had iteration upon iteration upon iteration of crisis in this, nobody knew when the next one was coming, because what they did know was that Parliament had been misled in terms of, the tap has been turned off, we're not doing this anymore. Parliament had been told that about 3 or 4 times, and it had not been true. And so no one trusted anymore, and that was essentially the problem.
That is the precursor to the coalition blocking supply in 1975. However, at the 1974 double dissolution election, the coalition had not won the numbers in the Senate to actually achieve this goal that they had been really hoping to do since the very beginning of the Whitlam government, basically. That changed because in 1975, in February, Senator Murphy, a Labor member, was appointed to the High Court, and therefore there was a vacancy. This was the first of 2 vacancies. The Liberal Premier of New South Wales put forward someone that the Whitlam government did not want as a replacement. There was a convention that when there is a vacancy in the Senate, to maintain the balance as it was at the last election, you would replace that person with someone who represents the party of the person who created that vacancy. The New South Wales Liberal Premier said that that convention only applied to death or, ill health. Basically, if you choose to leave, the convention does not apply. Similarly, then there was a death, unfortunately. Then you think, well, hang on a second, that also means that the convention should apply, but the death was of a senator in Queensland, and Joe Bjelke-Petersen, the Premier, was very anti-Whitlam, and so he took it upon himself to reject Whitlam's suggestions for a replacement and force in a member who was very vocally anti-Whitlam. But Whitlam, in his book, The Truth of the Matter, rages at this, says that, this is defying convention that has been established since basically the beginning. But it is ultimately a decision of those state parliaments, right? Was there any limitation? Was the New South Wales Premier correct about the convention only applying to death and illness?
It's a bit hard to tell. I mean, obviously, on the face of it, what happened in Queensland and New South Wales was dodgy, and I'm not defending it per se. In terms of the convention, it's a little bit difficult to establish because the electoral system for the Senate was different until 1949. And up until then, it sort of didn't matter because the Senate was elected by, extremes. So either one side would have a huge number or the other side would have a huge number. It was never important enough to matter how you filled the casual vacancies. That changed in 1949. And so in 1949, they did discuss, well, now that we've got this proportional representation system and the numbers in the Senate are going to be very close, do we have a convention about, filling these vacancies with someone from the same party, and how do we set that up? So one premier actually sent that round when the first vacancy came round and said, well, can we agree on a convention? Probably the majority of premiers said, yeah, that's right, we should appoint from the same party because whatever we do to someone else, they'll do to us. And so we should just be fair and do it that way. Some of them, however, were concerned about it and weren't quite sure. And one of them actually did point out, well, that's fair enough if you're resigning because you're sick or you're, for those sort of reasons, but not if you're being moved for a political purpose. So if there's some kind of political manipulation going on, you move someone out to an appointment so that you can fill it with another one, then I don't accept that that's a convention. So there was some debate about it back then. And one of the other things that happened was a question, and this again happened in Queensland earlier on, I've forgotten now when, maybe the 1960s. There was a question about, well, do you have to accept the only candidate proposed by the relevant party, or can you ask them to give you a list of 2 or 3 to choose from? Now, when that happened earlier on in Queensland, the relevant party said, okay, well, here are 2 or 3 and you can choose from one of them, and they did that. So in relation to Bjelke-Petersen, when the vacancy came up, Bjelke-Petersen said, well, we don't like your candidate, Mal Colston, who ironically later ratted on the Labor Party anyway, but that's another story. He said, but, give me 2 or other nominees and I'll choose from them. That was a huge strategic mistake from Labor because Labor refused to give him any other choices. And so when Labor refused to give him any other choices, Bjelke-Petersen advertised and said, right, if you're a financial member of the Labor Party and you want to be appointed to the Senate, come talk to me. And so that's where you get this guy called Albert Field. He was a member of the Labor Party. He was a very strong Labor supporter, but he hated Gough. And so he was the perfect candidate for Bjelke-Petersen. So Bjelke-Petersen puts him in, technically complying with the convention because he was appointing a Labor person to fill a Labor seat. Labor obviously expelled Field immediately afterwards. Bjelke-Petersen could say that in form he was complying with the convention, but in fact he wasn't. New South Wales was different. In New South Wales, they said, well, the only reason Murphy's gone is because you're trying to stack the High Court. We're not going to reward you for stacking the High Court with one of your Labor supporters by filling in with another Labor one, so we're going to appoint an independent. However, the person they did appoint was an independent, Cleaver Bunton, and when it came down to supply, Bunton supported Whitlam. So the New South Wales casual appointment of Bunton, even though they appointed an independent outside the scope of possibly what the convention was. And let me just say here, the reason we can't say absolutely that the convention wasn't qualified in that way or not, there just weren't enough examples or precedents to say there was a convention one way or another. It just hadn't happened enough, so you couldn't say, right? But nonetheless, New South Wales was playing a dodgy role there. In any event, it didn't actually alter the outcome in relation to the budget. So the thing that made the difference in relation to the budget was the Queensland appointment of Albert Field. Now, with Field, the government then claimed that he had a Section 44 problem. You remember that, when everybody was disqualified in the Great Section 44 crisis. So they said that he had an office of profit under the Crown because even though he had resigned his public service office before he was appointed, there was a period of notice that he should have given for his resignation, and that somehow made him still a public servant. Therefore, we'll take you to the High Court. So Albert Field had leave of absence from the Senate. So he never sat in the Senate or voted on supply. So on the one hand, you've got Bunton, who did vote for Labor on the supply, but you've got Field, who didn't vote one way or another because he was out, because there was this challenge against him. So while it didn't give the coalition a positive vote, what it did was it took away a Labor negative vote. And And that proved to be the crucial difference, because in the Senate, if you've got 30 all, which is what you would otherwise have had if Bert Milner hadn't died, or if they'd appointed a Labor candidate, it would have been 30 all. And if it's a 30 all vote, then that, according to the Constitution, the vote fails. So you still couldn't pass the budget on 30 all, okay? So we need to be clear about that. People seem a bit confused about that. But you couldn't have passed the budget anyway, regardless of these two casual vacancies. However, the key difference that it made was it gave the coalition the ability to defer supply positively rather than just have supply defeated. So if supply was defeated in the Senate, then that's it for the bill. It's out of the Senate. It goes back to the reps and the government controls the budget bill, right? But if you had that extra bit of a vote because Field's not voting, so you're actually at 30-29, then it means that instead the coalition can put up a positive resolution which says that we will defer voting on supply until such time as the government agrees to go to an election. Now, that meant that the budget bill stayed in the Senate. Now, that was a strategic advantage for Fraser, because he knew then if Kerr was contemplating dismissing Whitlam, Fraser could say, I can guarantee the passage of supply in the Senate enough, because otherwise, if Kerr wanted to dismiss Whitlam, pointless if Fraser can't achieve supply either, because supply will run out during the election campaign. So the bit about the casual vacancies, yes, was dodgy, probably shouldn't have been done. Whether or not it was actually formally a breach of convention, it was manipulating on the side of convention, and we can't be completely and utterly sure. But in any event, it was inappropriate. But did it make a difference? Only to the extent that it allowed the bills to stay in the Senate so Fraser could pass them if Whitlam was dismissed. It wasn't enough to get the budget through. The budget still would have failed.
Let's circle back to the reserve powers and Kerr. So Kerr justifies using the reserve powers, taking such a drastic step, because he firmly believed that Whitlam would not call an early election. That was the demand of the coalition. Give us an early election and we'll let supply pass. Kerr thought that Whitlam was just not going to bend on this, so he prepared the dismissal. However, on the 11th of November, Whitlam was going to Government House with a request for a half-Senate election. So Kerr knew what the request was going to be when he arrived. He didn't let Whitlam actually give him that request. He sort of just went, you know what, you are dismissed. I've made up my mind. That is how we're going to resolve this crisis. However, as you mentioned earlier, Governors-General don't have to automatically obey the Prime Minister. Couldn't Kerr have refused Whitlam's request and talk to him about it before dismissing him? I mean, we have examples in the past where Governors-Generals have refused early elections. The very first Labor government, Chris Watson, lasted 4 months and then he requested an early election. Governor-General said no. Alfred Deakin was Prime Minister 3 times. He also requested at one point an early election. The Governor-General said no. Wouldn't it have been possible for Kerr to receive formal advice for an election and go, I don't think that's solution, I'm still dismissing you?
Yeah, look, sure. And he should have. And that's essentially the problem with all of this in terms of how to manage it. Having said that, it's hard to say unless you're in someone's shoes, you know, how you behave in the time in the relevant circumstances. Interestingly, I've just been, as I said, in Windsor Castle reading correspondence from Governors-General, and one of the things precisely I was reading about was those refusals of dismissals and the explanation given back to the palace as to why they did, which was quite interesting. But anyway, getting back to Whitlam and what happened with the half-Senate election, if you go back to the 1974 double dissolution, that was when, again, the coalition had at least proposed to block or defer supply. That was in response to the Gare affair, where Whitlam had been trying to manipulate the Senate numbers by getting rid of a DLP person with an ambassadorial appointment and therefore getting the seat filled in and back to Labor. So there was some Senate manipulation going on there. It wasn't just the coalition doing it. Anyway, that caused the coalition to threaten to block supply. Whitlam then did what you ordinarily do in those circumstances, and that is you've either got to resign if you can't get supply or securing election. So Whitlam went to the Governor-General, asked for a double dissolution election, which would dissolve the whole of the Senate as well as the House of Representatives. That's all fine. But the interesting thing is, well, what did Hasluck say to him? Hasluck was the Governor-General then. And he said, yep, that's fine. I'll give you a double dissolution, but you have to secure supply to cover the election period. So Whitlam had already been warned that by another Governor-General, because historically, governors and governors-general would not give an election unless there was supply to cover the election period. Now, Whitlam, knowing that, came to Sir John Kerr on the 11th of November 1975 and said, I want a half Senate election. And Kerr had asked Whitlam, and again checked the morning on the day of the dismissal, do you have supply, or are you going to ask for supply to cover, temporary supply to cover the election period? Because probably Fraser would have granted it if he'd asked, because customarily that is what has happened. Okay. So Whitlam said no, and that was actually a politically strategic move, because the reason Whitlam didn't want a general election was that his government had become deeply unpopular. The Khemlani loans affair and all of these other scandals had meant, and not to mention that the economic problems at the time meant that he was convinced, and he told Kerr, that he would lose the election. So he knew he'd lose a general election if he had one. Why then hold a half Senate election? Now, the theory here from Whitlam's side was that he didn't want to get supply passed to cover the election period, because if supply ran out and there was all the chaos and people couldn't feed their families and people couldn't pay their mortgages and there was, huge protests on the street, Whitlam was gambling that people would blame the opposition for that. So Whitlam didn't want temporary supply, and he was quite assertive about that. He told Fraser that morning on the 11th of November he was not going to ask for supply to cover the election period, and he confirmed that with Kerr. And that was a political tactic, because it would distract the voters from all the carry-on about the Khemlani affair and the scandals and the economic position, etc., because instead people would be focusing on the drama of public servants not being paid, contractors not being paid, people not being able to feed their families and pay their mortgage and all those sorts of things. And the hope was that this would all be blamed on the opposition for blocking supply. And so the only way that Whitlam could see his way through to political success was by distracting the voters from his record and instead pointing the finger at the coalition, and then using that half Senate election as a means of reflecting community anger against the opposition. And so that was the political tactic behind it. So when Whitlam turned up to offer the half Senate election, or to request a half Senate election, Kerr knew that he wasn't in the position to be able to grant that half Senate election because supply would not cover the period. Now, Kerr then decided the best thing to do was to just dismiss Whitlam on the spot. And what might the rest of us have done? Well, personally, I think the more sensible thing would be to let him make the recommendation and then say to him, look, Prime Minister, historically, whenever this kind of thing has happened, the Governor or the Governor-General has insisted that a dissolution can only be granted, or an election can only be granted, in this case, a half Senate election, if supply is available to cover the period. So you need to go back to the opposition to secure the passage of supply, and you can tell them that I've granted you a half Senate election to do that. And if that had happened, and if Whitlam went back and said, well, the Governor-General's insisting that the opposition provide supply to cover this period, then probably the whole drama would have disappeared. You would have found out one way or another in the course of the election what the Australian people were feeling about both sides, and that would have then pressured a resolution in relation to supply after Parliament came back after the election. So, the best outcome would have probably been that. So was Kerr too rash and just say, no, that's it, it's over, you're sacked? Yes, I think he was. But having said that, the other thing to mention here is that people often say well, he should have waited till supply ran out. He acted too early. I think that's wrong because he and everybody else knew that he had to act either on the 11th of November or maybe at the latest the 12th of November. And that was in order to get an election before the Christmas period. And so for various complicated reasons about, polling booths and schools and people to, man the polling booths, etc., the Electoral Commission had told them that the last day that you could call an election before the end of the year, it had to be done on the 11th or the 12th of November, and that was it. After that, then you wouldn't have had an election until the new year. Okay, so that's really important for a couple of reasons. One of the reasons is that if you don't have supply, and it's going to drag on until you finally get an electoral resolution of it, you're looking at February in the new year before anything actually, an election is held and then the voting is done and then the Senate vote is completed and Parliament can sit. Going to drag it out for a hugely long period of time. That was unsustainable. And the second really important thing is that if you did need in the end to dismiss, you're going to have a caretaker government, a Fraser government, which doesn't have democratic legitimacy. And so you need to have the smallest time possible while they're there as a caretaker period before an election can be held. Having a caretaker government in the Fraser government governing all the way over into the new year and into sort of January, February would have been really bad. So from Kerr's point of view, he had to make a decision. He had to make a decision that day because Whitlam had come to him with this advice that day. So there was no doubt he had to make his decision. Then he couldn't wait to see whether the Senate was going to crack or whether the supply, wait till supply had run out. That just wasn't feasible in the circumstances from a practical point of view in terms of resolving the problem. But should he just have sat there calmly and explained to Whitlam, as indeed Hasluck did, sorry, you can't have an election unless supply is covered temporarily. Yes, he should have done that, and I don't think he handled it well.
A lot of focus when we discuss the dismissal is on Kerr. There were multiple ways that this crisis could have resolved itself. It's just that Kerr was the one that resolved it, and the way he went about resolving it is controversial. So it's the focal point of all the discussions. But let's take a step back. What about Whitlam? Is there not a convention that if a government can't have both confidence in the lower house and supply through both chambers of parliament, that government should resign? Was there not an element where Whitlam should have reconsidered his role as Prime Minister, not just waited until Kerr forced him to consider it?
Yeah, look, and the funny thing is Whitlam, of course, recognised that back in 1974. So he did accept that if he couldn't get supply, he needed to either resign or call an election. And so he got an election. And so he followed the normal course then. But in 1975, he just decided he wasn't going to follow the normal course. And that's where he became a cropper in the end. People, because this hadn't happened at the Commonwealth level before, people assume that there were no sort of conventions, etc., about how to deal with this. But it had happened quite a number of times at the state level. So upper houses had blocked supply at the state level. Upper houses had forced governments to an election at the state level. This was not an unusual tactic. It had been used by Labor as an opposition in the upper house at a state level to force Conservative governments either to resign or hold an election or be dismissed. And so there are a number of occasions in Victoria where Conservative premiers were effectively dismissed. And the reason we don't think of them as dismissals is they didn't use the word. So what they did was they said that they were required to resign by the governor. And so they signed a piece of paper saying they resigned, but it was compulsory. The governor said you had to, and that was it, because you were out. And so that did happen in Victoria. So there were precedents for this, and there was a well-standing practice that if you couldn't get supply, then the governor had to choose someone else who could. And by choosing someone else who could, or you had an election. If an election was inappropriate because an election had happened really recently, or if the government wasn't prepared to advise an election, then the governor would choose someone else. And they would choose them on the condition that they could get supply. Ultimately, if people couldn't get supply, they go for an election. So all of that had happened in the past, not at the Commonwealth level, but certainly at the state level, particularly in Victoria. So it had happened in the 1940s and the 1950s in Victoria, which was within living memory of 1975. Whitlam, however, probably didn't seem to know a lot about it. Fraser did. Fraser was a Victorian. Whitlam was from New South Wales, and his only sort of knowledge about governors and dismissals was the Lang dismissal, but really he should have been looking at Victoria. So there was a bit of a lack of knowledge or understanding perhaps going on there, but Whitlam knew there was a risk of him being dismissed. He was constantly telling the Governor-General, the only way that you're going to get an election is if you dismiss me. It wasn't a surprise to the extent that he didn't know that this was on the cards or a possibility. It was only a surprise to Whitlam because he made a judgment of Kerr's personality. And his judgment was that Kerr was too weak to do it. So every time anyone warned Whitlam and said, look, I think he's going to dismiss us, Whitlam would just say, no, he doesn't have the guts. But that's an assessment that Whitlam made personally. It wasn't a proper assessment on the basis of what the various constitutional rules were. So Whitlam just seemed to think he could get his way. It was the crash or crash through. Well, if you're going to take that strategy, you've got to be prepared to crash.
Whitlam, as we've established, was very firm in his resolution that he wanted to get his way. His plan was to break the Senate, I believe the phrase was. He basically did not want the Senate to tell him when an election should be, and supply was running out. However, he had a backup plan. Now, this backup plan, I have no idea if it was legal, and there are conflicting views about that. So his idea was, well, if the coalition forces us to run out of money to pay public servant wages, let's talk to the banks, have them cover it temporarily, and when finally the coalition breaks under the gaze of Whitlam and passes supply, the Commonwealth can then pay those banks back. There were lots of different opinions about this. A couple of major banks sought legal advice. They believed it was illegal. Kerr also was very critical of this idea, thought that it was illegal, and compared it to Charles I trying to rule without parliamentary approval. However, Bill Hayden, who was the Treasurer and then Governor-General later on the contrary, thought it was actually legal and fine. Whitlam's idea was to use the Audit Act to enable this. Was that plan legal, or was that just a ridiculous idea that just would not work?
So there's quite a lot in there. The first thing to just say is that they tried this in the 1870s. So they actually did this. It was quite sneaky. What they did was that they, because the Premier was the director of a bank, and what they did was that they'd get a loan from the bank, and then the government would default on the loan, and then the bank would call in the loan and go to court and say, you've got to give me my money back. And the government would say, we're not defending it. Of course, you need your money back. And then under the Audit Act, there was a thing saying that you could pay out of consolidated fund any money owed under a court judgment. And then they just keep doing that every month.
I love that story, by the way. It is ridiculous. James McCulloch, I believe, is the name of the Premier, and he ended up borrowing and then suing himself, technically, for, I think it was like £800,000 in the 1860s. Anyway, yes, so
the whole bank ruse had been tried before. The key thing that comes out of that, though, is that when the British got, had a look at all of this and got really angry and then demoted the governor and sent him off to Mauritius, it was because of a fundamental principle. And that fundamental principle is that governments require supply to operate passed by the Parliament, that appropriations are controlled by the Parliament. If you're a government and you can bypass Parliament and you can operate without Parliament, then you're bypassing a fundamental aspect of the Constitution, because that's the one key thing in a system of responsible government that forces the government to be accountable to Parliament. It's the fact that government can't carry on without parliamentary appropriations. So say, for example, a government decides, we're going to declare war on New Zealand. And the Parliament's like, no, sorry, the Parliament has to pay for a war. Governments can't run wars without Parliament approving it, right? And in terms of not them approving going to war, but in terms of them approving the money to be able to fund the war. And this goes back to, centuries of fights between monarchs and Parliament. So the British are very conscious of this, and that is that a fundamental part of our system of government is that government should not be able to operate outside the constitutional system to get money to be able to function, because they have to be responsible to Parliament and Parliament's control over the budget. And that's why they got stuck into the governor for approving that. Okay, so that's the history part of it. In terms of the actual proposal that Whitlam had, it was a bit different. It wasn't the one about, let's just sue the borrow money and then default and then sue the bank. It was, we'll give you a certificate for each one of our public servants. They have this certificate saying that they owed money. They go to the bank. The bank then takes the certificate to be able to get the money, and it gives its money to the individual, and then the bank eventually presents it to the government, and the government will pay them in the future. That essentially was the system. Whether or not it was legal, there were different views about it. So, as you say, there was a legal opinion by John Lockhart. He said that there was no legal right of the public servant to any money that hadn't been appropriated, and therefore it didn't work. Whether or not that's the case, I don't know. I decided in the end it just wasn't worth trying to work out all the financial ins and outs of the Audit Act back in 1975 to know. But what I do know, and anyone else can do this as well, because it's quite interesting, I went back to the National Archives, and they have digitised the files from Treasury, which are about this proposal. And for anyone who wants to do it themselves, start at the one at the end, I think it's volume 8, and then work backwards, because you can see all the stuff from the banks about this and whether it was going to work or not. Whitlam only went to the banks with this proposal on the 6th of November and said, quick, you've got to approve this because we're going to run out of money really soon. And the banks are saying, hang on a second. A, there are real doubts about whether this is lawful or not, and we've got legal advice suggesting that probably it's not. But B, and this was the bigger problem, it's completely and utterly impractical. You haven't given us a proper system that would work. And so they had issues about fraud, for example. Anyone could come up with a certificate and say, I'm a public servant, give me some money. The banks aren't going to know and be able to identify who are the people who are genuinely the people who need to be paid, etc. And so they said there's all sorts of problems in relation to fraud. There's all sorts of problems in relation to like public servants who are under 18. Apparently there were quite a lot of them, wouldn't have had a right to be able to transfer their indebtedness, etc., because they were under the age of being able to do that. And they raised a huge list of problems, and they said, look, this might be a proposal that if we worked on it seriously for a couple of months, we could come up with something that works. But they said, in the meantime, you need an answer from us quickly saying that we're going to do this. The answer is no, because we can't see that this is going to work, and we have all these legal problems with it. So basically the banks were not going to come on board. So the government and Kerr and others knew that this was the problem. They couldn't manage to make the system work that quickly. Hayden, for example, and this I think is quite interesting. If you go back to his autobiography, he said it was a political bluff. If you've got it on the wall there's a good section in it where he said he didn't think it would work properly. He went along with it as a political bluff, but in the end he thought it would all fall over. And so,
yeah, which page?
That's the one. Have a look in there. So Hayden wasn't even convinced by his own proposal.
Yeah, it's looking like Kerr isn't the only one who had some unconventional and controversial decisions in this crisis. But let's talk a little bit about Kerr and Fraser. So on the fateful day of the dismissal, before it all happens, like 9:15 in the morning or something like that, Kerr contacts Fraser. And he discusses the possibility of appointing him as Prime Minister. And in the process of doing this, he has some terms and conditions. One, no major policy decisions until after the election, no royal commissions into the previous government. I think there's a couple of other ones. The Governor-General is basically saying, you can be the government if you agree to X, Y, and Z. The Governor-General is apolitical. Is there an issue here with the Governor-General or a governor imposing terms and conditions on an incoming government? And could Kerr have done anything if Fraser went, yeah, sure, and then completely ignored that after becoming Prime Minister?
Yeah, this is an issue that's been debated a number of times. One thing I should say first, however, is that there is a dispute about whether or not Kerr did contact Fraser about that before the dismissal. Kerr said he didn't. Fraser later said that he did. There is a piece of paper with the conditions written on them, but there's a dispute about the date and time on it. So who knows? I wasn't there. For my money, he probably did, but whatever. But the issue about whether you can impose terms and conditions, well, firstly, partly they would have been imposed anyway by the idea of a caretaker government. So we do have conventions about what a government can and cannot do when it's operating in a caretaker capacity. And in this particular case, it was a caretaker capacity because the Fraser government did not have the confidence of the lower house. And that would automatically have meant that Fraser would have been subject to the ordinary caretaker rules, so not able to make substantive policies and appointments and all of those sorts of things. So a number of those conditions were naturally already within the existing conventions. But there were other conditions that were important. One was achieve supply. There's a big issue there because if Fraser hadn't managed to achieve supply, so if Gough hadn't gone off and had his stake, if he'd told the people in the Senate, if they delayed bringing on the budget bills, then in those circumstances, then it's quite possible Fraser wouldn't have got supply, and that would really have put the cat amongst the pigeons in terms of what Kerr would do then. So that was an important one. And the second one was that that Fraser advised double dissolution. And the reason for doing that was fairness to Whitlam. And this is, again, something that's not often recognised, but Kerr actually did do his best, despite the dismissal, to be fair to Whitlam. And that was to ensure that every single one of those bills that had been blocked, every one of Whitlam's bills that had been blocked in the Senate by Fraser, was listed as a double dissolution bill, so that if Whitlam had won the election, but not a majority in the Senate, he could have come back with a joint sitting to get those bills passed. So Kerr deliberately gave him that fairness and got Fraser to act against his own interests in using those double dissolution bills. So that in itself is also interesting. But the thing to note here is that the conditions that Kerr imposed were, again, not conditions because of what Kerr personally wanted, but to serve a constitutional purpose. And that constitutional purpose was democracy. So he wanted to ensure that the people got the chance to make a decision, both in relation to the lower house and the upper house, and that's why a double dissolution was called. It was fairness to Whitlam to ensure that he had a chance, if he won in the lower house, to get those bills through. The final one was also making sure that supply covered the period so that people wouldn't suffer. So, in those circumstances, I think the conditions that he imposed were fair enough. And the other one, of course, was don't use your power while you're in government to investigate the previous government and find more scandals against them. Again, I think that's utterly fair to Whitlam to not allow Fraser to exploit his position as a caretaker to do that. But in terms of the technical question of, well, what status do these conditions hold, and what could the Governor-General do if the Prime Minister then turned around and said, not doing that anymore? That issue arose in, I think it was like Tasmania in the very early 20th century, where a condition was placed upon a Premier who agreed to it and then reneged on it later on. And the reality is, in most cases, there's nothing you can do unless you're prepared to dismiss them. And if you can't dismiss them unless you've got someone else who can form a government. For the most part, these sorts of conditions are morally and politically obligations on the person who made the commitment, and mostly they comply with them. So pretty much every circumstance in which a condition has been imposed upon an incoming government, they have complied with it. Ordinarily, when a condition is imposed on an incoming government in these sort of circumstances where the previous one has been sacked, it's that you advise an election immediately. And that's always been complied with. There's a reason for doing it in most cases. It's normally complied with, but if it's not complied with, then there's usually nothing the Governor-General can do about it, other than say you're absolutely disreputable for breaching your word and making that publicly known, which of course would be politically devastating. The one exception here was supply. If Fraser had not achieved supply by the end of the day in 1975, I don't think anyone knows what would have happened at that point. Would Kerr then have said, right, we're going to a double dissolution election and allowing supply to run out during that election? Or would he have reinstated Whitlam? I don't know. I don't think he knew either. And because of that, I think the whole thing was really badly planned, because I don't think Kerr understood enough about parliamentary rules and the fact that it could have all gone off the rails. I think he just thought that Fraser could guarantee supply and it would be passed in a flash. And he was just really lucky that Whitlam totally ignored the Senate and didn't sort of have any tactics to deal with it. Because if supply had not been passed, there would have been a real problem.
On the 11th, Fraser does become Prime Minister, and Whitlam does not tell the Senate that he has been fired. So they do pass supply, and Labor senators are like, oh yay, we did it. We solved it, everyone. The coalition caved without realizing that Whitlam has been sacked. They are not the government anymore. But when the news breaks in the House of Representatives, there is an uproar. There is just yelling. There's this massive anger at this, and basically immediately they manage to pass a motion of no confidence in the Fraser government. The convention is, if you don't have the confidence of the lower house, you should resign as the government. At that point in time, the election had not been called, so the Speaker decides to personally deliver the news to Government House to inform Kerr that the lower house, the House of Representatives, has no confidence in Fraser and Whitlam should be reinstated as Prime Minister. Kerr does not let the Speaker in for like an hour or more. Like, the Speaker is at the gates of Parliament House. Kerr knows what he's coming to tell him, and he's just like, nope, I'm not going to let you in. Instead, decides to carry on with the advice he's received from Fraser, which is dissolve both houses of Parliament now that supply has been passed. Labor's argument at the time was, well, A, supply has been passed, so the crisis has been resolved, and therefore B, because the crisis has been resolved, we don't need to go to election, and C, the Fraser government does not have the confidence of the lower house, therefore D, Whitlam should be reinstated as Prime Minister. But because the Speaker was unable to deliver this news until after Parliament had been dissolved, it's kind of a moot point. Was Kerr obliged to actually hear the Speaker deliver that motion of no confidence? Is there actually some sort of constitutional relationship where Kerr should have acted differently, or was it, basically, as I pointed out, a moot point, because the request was, hey, reinstate a government that is about to go to an election anyway, and therefore Kerr was not shirking responsibility.
So the first thing to go back to is, what is the convention if there's a vote of no confidence against you in the lower house? And the convention is that you either resign or secure an election. So, and that's the most common part. If you lose support in the lower house, you do go to the governor or the Governor-General and you ask for an election. And that's what's happened in the past. So Fraser, having been subject to a vote of no confidence in the House, was perfectly entitled to ask Kerr for an election. And Kerr was totally entitled to grant him that election. That's completely normal according to convention. So Kerr had that choice. It wasn't the case that Kerr was breaching convention by saying, I'll give you an election even though a person had lost a vote of no confidence, because that was, common ordinary practice. If you've lost a vote of confidence in you, then you can either resign or secure an election. So I think the whole thing about leaving the Speaker outside the gate was a bit unnecessary and overly dramatic. Could have let him in and given him a cup of tea, frankly. It wouldn't have made any difference. But Kerr did, while the Speaker was sitting out there, he did take legal advice. And so he took legal advice from the head of the Attorney General's Department and the Solicitor General about whether now that he had started this process of dismissal, appointing Fraser upon conditions that Fraser achieve supply and advise a double dissolution, given that he was in the middle of that process, could he continue that process given that the House of Representatives had voted no confidence in the lower house? And the legal advice was yes, you have started that process. It was a condition of the appointment of Fraser, so you told him in advance that he needed to get supply, and he did, and that you would give him a dissolution, moreover that he was obliged to advise you to do a double dissolution, and in those circumstances Kerr was perfectly entitled to continue on with it. So I don't see any of that as controversial in terms of from a constitutional point of view. Kerr was absolutely entitled to act as he did, and in fact, just if you think of what the controversy would be that we'd all be sitting about and talking about 50 years later if the reverse had happened. So just think to yourself, well, what would have happened then if Kerr suddenly turned around and said to Fraser, well, you delivered supply in the upper house, ha ha, I'm now dismissing you because there was a vote of no confidence in the lower house. I'm appointing Mr. Whitlam and he's got supply until, for the next year. Everyone would have then be complaining, well, wait a minute, Kerr was a Labor appointment. He was Whitlam's man, that he deceived Fraser by telling him that, he'd dismissed Gough and that he was appointing Fraser as Prime Minister in order to get supply. And then once Fraser had got supply, Kerr would sack him, and it would all be for the benefit of looking after his mate, Gough Whitlam and the Labor Party. We would all then be arguing that Kerr was deceitful and duplicitous and had manipulated Fraser and the coalition in order to support the Labor Party, and how inappropriate and appalling what he did was. Had he done that at that point, he would have been subject to a huge amount of criticism. Last point to make on that, however, and this is the interesting one, if Whitlam had actually known his constitutional history, particularly his Victorian constitutional history, he could have pulled this one out of the bag, and it would have been quite interesting, because similar sort of scenario happened in Victoria. You had a government in the lower house with a majority. You had an upper house that blocked supply. And so in the end, the governor appoints a person in the upper house who controls it in order to get supply. And he does so, dismissing effectively the lower house, the guy who had majority in the lower house. And then when the fellow in the upper house, who not only said, I can get supply, but I can also manage enough people in the lower house to keep governing, when he discovers that he's got a vote of no confidence against him in the lower house, he says, well, give me an election. And the governor said, well, no, hang on, although you did get supply, nonetheless, you did tell me that you were going to have enough numbers in the lower house to get through a redistribution and do these other things, and you failed. There's been a vote against you of no confidence in the lower house. So what am I going to do? Of course, I'm going to go to the Chief Justice and ask for advice, because that's what everybody did in those days. I'm going to go not just to the Chief Justice of the Supreme Court, but I'm also going to go to the Chief Justice of the High Court. And the Chief Justices tell him, well, actually, you should reappoint the person who had the majority in the lower house, appoint him as Premier, and then get him to go to an election. So that is actually what happened in Victoria. They restored the person in the lower house who had the majority, brought him back into government, but for the purposes of holding an election. Whitlam could have argued to Kerr, on the basis of advice by Chief Justices, that would have been the appropriate course. But of course, Whitlam wasn't really up to speed with those earlier precedents. But, if Sir John Kerr had been faced with the fact that Sir Owen Dixon, predecessor of Garfield Barwick in the High Court, had given that advice in those circumstances, that really could have potentially caused Kerr to change his mind. But in the circumstances, nobody had really figured out the relevance of that precedent.
It seems like Kerr just could not have won, no matter what he did in this situation. It was a tough place for him to be in. Malcolm Fraser, as leader of the opposition, he is very adamant that dismissal is the solution to the problem. He is creating a crisis of blocking supply to try and engineer that, and publicly shaming the Governor-General to say, it is your public duty to dismiss the government. He is also having private meetings with Sir John Kerr, some of which were authorised by Whitlam. Some of them Whitlam did not know about. A member of the Liberal Party under Fraser, Bob Ellicott, writes a legal opinion and publishes it in the newspaper, also arguing, it is the public duty of the Governor-General to dismiss a government if they cannot get supply through. Are there any issues around Fraser's approach to this crisis? Both Fraser and the fellow Liberals publicly trying to pressure the Governor-General? Is that not sort of trying to exert political pressure on an apolitical office, even if it is a legal opinion? And should Fraser have been going about having these meetings with Kerr without Whitlam's approval of every single one of them? Or is it like, well, these are two people, they are allowed to have a meeting?
Well, look, yes, there was a lot of political pressure applied to Kerr, both by Whitlam and by Fraser, both of which was inappropriate. So on Whitlam's side, he kept on bullying Kerr by saying, Kerr can only do what I tell him to do, basically treating him as an automaton, saying he had to do only what the Prime Minister said, etc., which was not correct. Fraser's side, yes, they went too far in saying, Kerr had a duty to dismiss, that he would be failing in his duty if he did not do so. Having said that, this is also a hallmark of every other constitutional crisis I've ever read as well. So whenever you read the correspondence between a governor or a Governor-General and the palace about these sorts of crises, there's always pressure imposed by people saying, the governor or the Governor-General is failing in their duty by doing this, that, and the other. And so it's not uncommon. It does happen from time to time. People will publish and say, they have to do this or they shouldn't do that. So, you would hope that a Governor-General would be made of sterner stuff to not worry about those sorts of things too much. If you go back and read the stuff that was written at the time of leading up to the Lang dismissal, for example, the sorts of letters and pressure put on Sir Philip Game was absolutely horrendous. So it can be a position in which a lot of pressure is put on you. It also comes back to that second issue about advice. So Whitlam said that only he could advise the Governor-General and that nobody else was allowed to do so. Now, that's sort of partly true and it's partly not. So it depends on what you mean by advice. There's what the palace calls capital A advice, and that's advice that is the formal advice that you receive from ministers to exercise your powers. And of course, only responsible ministers can give that. So the Chief Justice can't give you capital A advice, and nor can the Leader of the Opposition or anyone else, right? But there's also other type of advice, which is just, talking to people and people sort of saying, well, here's my view about the scope of your power and that sort of stuff. That's not the formal kind of advice. That's what the palace calls small a advice. And anyone can give you small a advice. So if you look at other constitutional dramas, like say in Tasmania, for example, where from time to time there have been, issues about who should be appointed premier. On one of those occasions, there was something like 20 or 30 legal opinions were gratuitously sent in to the governor at the time. So a lot of people provide advice of that kind, but it's nothing that actually, causes or instructs the governor or the Governor-General to do anything. It's just information that they can either discard and throw in the rubbish bin, or it might be information that helps them be better informed when they make a decision. So governors and Governors-General will attend lots of public events. And at those public events, they'll see politicians, including opposition politicians. So the Governor-General will run into Malcolm Fraser at events. The Governor-General will run into Sir Garfield Barwick at events, for example, the Chief Justice. The Governor-General will run into senior public servants. Reading one of the senior public servants files recently, I was amused to read that he was so terrified by Whitlam and Whitlam's views about advice to the Governor-General that this guy would avoid the Governor-General at all sorts of public events just for fear that he would be seen talking to him, and that would be regarded as advice. People got quite paranoid about it. But the reality is, of course, people in those senior positions see each other and talk to each other all the time. They're sitting next to each other at dinner. They're having drinks with each other. It's impossible to not talk and communicate about whatever the issues are of the day. And so Whitlam went way too far in terms of trying to control the Governor-General and the sort of advice that he could receive. Whitlam was absolutely right. Only formal advice can actually advise the Governor-General to perform certain acts and exercise certain powers. But this other kind of informal advice, discussion, etc., was not something that was in Whitlam's control.
Well, that answers one of the questions that I didn't ask earlier about how Kerr sought advice from Barwick, but also asked Whitlam ahead of time if he could consult with Barwick, and Whitlam said no, and Kerr did it anyway. My question was going to be like, is that actually the kind of advice that Whitlam can give to a Governor-General? Don't talk to a Justice of the High Court about this, or is that an overreach of the Prime Minister's power to advise, which I think you've just neatly summarised then. We're basically near the end. In summary, it seems like there were quite a lot of issues surrounding this dismissal, and while the focal point very much tends to be on the act of dismissal by Kerr himself, it's not just Kerr who is taking an unconventional approach or doing things that might be a bit unconstitutional or challenging our parliamentary norms. Is that a fair way to summarise the dismissal? It is very multifaceted, complicated, and there is no singular person to point to everything going wrong.
Yeah, I think that's right. I mean, it's a thing that's got a huge number of different constitutional issues. There's a lot of misunderstanding about the Constitution that was going on there, even amongst the players, because these issues tend to arise relatively rarely, so most of them would have had no experience in them, so that was problematic. There was the personalities involved. So the personalities were all pretty extreme. Gough, Malcolm, Sir John Kerr, all of them had their own sort of personality traits that led to this sort of tragedy. If anyone else had been there or in the chair, it would have turned out differently. And I think we can all be certain of that. But there were a whole lot of moving parts. I don't think it can be characterised as just one narrative of, one sort of evil act going through. It was a whole combination of a whole lot of different circumstances. There were many points at which the whole thing could have turned out differently, and it didn't. But just makes you wonder how many of these sorts of occasions might have occurred in the past, but all got derailed on the basis of one little thing here or there, and so never happened. Who knows?
Of course, we'll never know, because all the real information is destroyed by the CIA, who was controlling Kerr the whole time.
Thank you.
Because I'm absolutely going to get a million comments about that. Well, thank you very much once again for your expertise and enlightening us about the Constitution and Australian history. I appreciate these chats every time.
Glad to do so.
And of course, everyone should check out your YouTube channel, Constitutional Clarion.
It delves into each one of these little issues in lots more detail.
And there you have it. Thank you so much for tuning in to Auspol Explained. And again, thank you so much to Professor Anne Twomey for her expertise and knowledge to help us understand a bit more of the dismissal and give us a broader, more well-rounded view of it than we often hear. I highly recommend, of course, checking out the Constitutional Clarion, her YouTube channel, where she has more in-depth videos where she talks more about some of the stuff that we've talked about here and other elements of the dismissal as well, and other general explainers about the Constitution. I find that when I have a question about the Constitution, I do some Googling and discover, lo and behold, Anne Twomey has already written a paper about the question I wanted the answer to. So a fantastic resource to go and watch. And if you've made it this far and are not subscribed to me, solve that. It's time for you to subscribe to Auspol Explained. Give me a like, comment down below what you would like to learn about next, or, you know, your personal opinions about the dismissal, whatever they may be, which I don't need to prompt you. You definitely will have an opinion. And that's okay. We all have different views about this. And if you like, you can also give me some money on Patreon. I appreciate that immensely, and I will use it to hoard wealth so that I may purchase things that I need. The link is in the description, along with some links to other social media you can follow me on, like Instagram, all the other ones. Anyway, that's all from me. Thank you so much for tuning in. I'll see you next time.